Domestic adoption under Republic Act 8552 or the Domestic Adoption Act of 1998. What is adoption? Adoption is a socio-legal process of giving a permanent family to a child whose parents have voluntarily or involuntarily relinquished parental authority over the child. Types of adoption. In the Philippines, there are two types of adoption recognized by the state. First is the agency adoption, and second is the family or relative adoption. Agency adoption is one where a licensed adoption agency finds and develops adoptive families for children who are voluntarily or involuntarily committed to the state. The adopted families go through the process from application as prospective adoptive family facilitated by the Department of Social Welfare and Development or a licensed child placing agency to finalization of the child's adoption in court. Family or relative adoption, on the other hand, is one where the biological parents make direct placement of the child to a relative within the fourth degree of consanguinity. Who may adopt? The following persons may adopt. A. If the adopter applicant is a Filipino citizen, he must be of legal age, at least 16 years older than the adoptee, but this requirement may be waived if the adopter is the biological parent of the adoptee, the sibling of the adoptee, or the spouse of the adoptee's parent. 3. Has the capacity to act and assume all rights and duties incident to the exercise of parental authority. 4. Has good moral character and has not been convicted of a crime involving moral turpitude. 5. In the position to support, educate, and care for his or her children and the child to be adopted. And 6. Has undergone the required pre-adoption services. If the adopter applicant is an alien, in addition to the requirements stated above, he must also be 1. A citizen of a state which has diplomatic relations with the Philippines. 2. Has been living in the Philippines for at least 3 continuous years prior to the filing of the application for adoption and maintains such residence until the adoption decree is entered. 3. Certified by his or her diplomatic or consular office or any appropriate agency that he or she is qualified to adopt in his or her country. And 4. His or her government will allow the adoptee to enter the adopter's country and reside there permanently as an adopted child. The requirements on residency, number 2 above, and the alien's qualification to adopt in his or her country, number 3 above, may be waived if the alien applicant is A former Filipino citizen who seeks to adopt a relative within the fourth degree of consanguinity or affinity. B. One who seeks to adopt the legitimate son or daughter of his or her Filipino spouse. Or C. One who is married to a Filipino citizen and seeks to adopt jointly with his or her spouse a relative within the fourth degree of consanguinity or affinity of the Filipino spouse. The guardian is also qualified to adopt the ward, but the application for adoption may be made only after determination of the guardianship and clearance of his or her financial accountabilities. Joint adoption of husband and wife. Husband and wife shall jointly adopt except in the following cases. 1. If one seeks to adopt the legitimate son or daughter of the other, or 2. If one spouse seeks to adopt his or her own illegitimate son or daughter, provided, however, that the other spouse has signified his or her consent thereto, or 3. If the spouses are legally separated from each other. In case husband and wife jointly adopt, or one spouse adopts an illegitimate son or daughter of the other, joint parental authority shall be exercised by the spouses. Who may be adopted? 1. any person below 18 years of age and has been administratively or judicially declared available for adoption. 2. The legitimate son or daughter of one spouse by the other spouse. 3. An illegitimate son or daughter by a qualified adopter to improve his status to that of legitimacy. 4. A person of legal age if, prior to adoption, has been consistently considered and treated by the adopter as his or her own child since minority. 5. A child whose adoption has been previously rescinded. And 6. A child whose biological or adoptive parent has died, provided no proceedings shall be initiated within 6 months from the time of death of said parent. Whose consent is necessary to the adoption? After having been properly counseled and informed of his or her right to give or to withhold his or her approval of the adoption, the written consent of the following to the adoption is required. 1. The adoptee, if 10 years of age or over. 2. The biological parents of the child, if known, or the legal guardian or the proper government instrumentality which has legal custody of the child. 3. The legitimate and adopted sons, daughters, 10 years of age or over of the adopter and adoptee, if any. 4. The illegitimate sons or daughters 10 years of age or over of the adopter if living with said adopter and the latter's spouse, if any, and the spouse, if any, of the person adopting or to be adopted. Effects of adoption. 1. Except in cases where the biological parent is the spouse of the adopter, all legal ties between the biological parents and the adoptee shall be severed, and the same shall be vested in the adopter. 2. The adoptee shall be considered the legitimate son or daughter of the adopter. 3. The adoptee is entitled to all the rights and obligations provided by law to legitimate sons or daughters born to them without discrimination of any kind. And 4. The adoptee is entitled to love, guidance, and support in keeping with the means of the family. Rescission of adoption. Adoption may be rescinded on any of the following grounds committed by the adopter. 1. Repeated physical violence and verbal maltreatment by the adopter despite having undergone counseling. 2. Attempt on the life of the adoptee. 3. Sexual assault or violence. Or 4. Abandonment and failure to comply with parental obligations. Adoption being in the best interest of the child shall not be subject to rescission by the adopter. However, the adopter may disinherit the adoptee for causes provided in Article 919 of the Civil Code. The adopter is not allowed to rescind the adoption, but he may disinherit the adoptee for causes provided under Article 919, which is applicable to children and descendants, legitimate and illegitimate. These grounds are the following. 1. When a child or descendant has been found guilty of an attempt against the life of the testator, his or her spouse, descendants, or ascendants. 2. When a child or descendant has accused the testator of a crime for which the law prescribes imprisonment for 6 years or more, if the accusation has been found groundless. 3. When a child or descendant has been convicted of adultery or concubinage with the spouse of the testator. 4. When a child or descendant by fraud, violence, intimidation, or undue influence causes the testator to make a will or to change one already made. 5. A refusal without justifiable cause to support the parent or ascendant who disinherits such child or descendant. 6. Maltreatment of the testator by word or deed by the child or descendant. 7. When a child or descendant leads a dishonorable or disgraceful life. And 8. Conviction of a crime which carries with it the penalty of civil interdiction. Rescission of adoption has the following effects. 1. The parental authority of the adoptee's biological parents, if known, or the legal custody of the DSWD shall be restored if the adoptee is still a minor or incapacitated. 2. The reciprocal rights of the adopter and the adoptee to each other shall be extinguished. 3. The court shall order the civil registrar to cancel the amended certificate of birth of the adoptee and restore his or her original birth certificate. And 4. Successional rights shall revert to its status prior to adoption, but only as of the date of judgment or judicial rescission. Vested rights acquired prior to judicial rescission shall be respected. Thank you. A discussion on inter-country adoption will follow shortly.